that you do need to in fact file a formal withdrawal.
Well, Your Honor, I just would like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. You know, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation when you...
What? I mean, I know he wants it in writing, but damn. Woody doesn't want her as his lawyer. What's the issue here? Mr. Melnick announced on Friday that he was going on vacation next week. It almost seems like the state purposely did the whole ex parte meeting with the judge and Woody without his usual lawyer there that wouldn't let some shit like that happen. And it was a replacement lady in there. The judge thinks it was her that leaked it to Brian Steele.
What does he want to tell me?
I don't want to say in open court.
This is so awkward. They think it was her that leaked it because she was in there.
All right, state, this focus, come on. And I don't believe you have directing questions.
Wait, hold on. The defense can't come up there? Why is it only the state and her? This is getting sketchy again. What? Why can't the defense come up?
We are now being excluded from a conversation about material witness. And Your Honor, just doing that, but creates the appearance of it. So I have to.
Okay. I'd like to say, I'll not introduce that, I'd like to say, also, under Article 1, Section 12 for the Constitution, also denies Mr. Williams his right to a critical stage of proceeding.
So all the defense lawyers objected to this private conversation, and now it didn't happen, really. I think they all just left before it even happened.
As a person for which the state made that motion are involved only, then the parties to that matter are the state and Mr. Copeland. And so for that reason, I believe that Ms. Bumpus is entitled to address the court with the other party in that matter, which is the civil contempt entered by the court on the motion of the state.
So I don't know if she's right. Any lawyers watching, comment down below, but still pretty sketchy. Why not just have one defense lawyer come up to listen?
I don't know what she's going to say, so that may make it not subject to ex parte or not. But what does he want to tell me about it? Can you tell me the subject matter?
What I'm trying to say is something that happened during the ex parte matter, which is why I don't want to say it in open court.
No, I'm good. I'm good at this point in time. I think you need to go ahead and reduce it to writing.
But Your Honor, I was representing him for the civil contempt, not as a witness. So that once he purged himself, I should have been released.
That's true. Yesterday, Woody was released after he testified. He wasn't held in contempt anymore.
At this point, the court is still of the opinion that you need to file a motion to withdraw the client. You want your lawyer's not in here.
She's not my lawyer.
No, but you still have the opportunity to decide that, okay?
Oh my gosh, man.
Miss Melanie told me that she was only going to be here for 1 day.
See, I have no knowledge of those things.
Just omitting a lot of evidence of pictures. Bro is currently on the verge of falling asleep right now or something.
Seriously.
What? What was he just doing? That was strange.
Yeah, I see it. Yeah, there's blurry too. I cannot see who in it on the computer. Me ain't got the up. I'm not good at reading.
This guy doesn't drink water, he has vision problems, and he's not good at reading.
2014.
You know that's in 2014?
Okay, my bad. 2014.
All right, well,
317.
all right.
It look like an R.
Mm-hmm.
Love.
All right.
Bye.
Mm-hmm. Okay.
Is he for real, bro? This is so painful.
And Woody 372, is that you? Is that you? Is that your Instagram name? In 2014, but that's your Instagram name.
It's me ain't got the me and my real WOD.
Okay. And you see the same Instagram name?
Woody 372.
All right. And that's you, the same picture?
The same thing.
Is that you in the picture? And they call you Woody, right?
WOODY.
Okay. And what's the next to that?
ELATT.
Okay. And what's the next to that?
SLATT.
Getting warmed up now.
Her black and slack.
Yeah, I heard that.
Okay, but that's what that picture.
Screwed in court.
Mike get dead in.
Is there a hashtag after that?
UDIGG.
All right. Now the first part, does that work with the hat?
Pat. Is that what it's pronounced?
I can't tell if he's serious. Is he actually this, like, bad at reading?
He look like you have to look. Hayden, as follow, stay where y'all at, and everyone else.
This is literally a Key and Peele skit.
You have to look at me. Me, you have to look like a shooter or clothing stuff.
He knows Duke, Thug, and Yak. We know this. Like, we're 5 hours into the stay. This is just, we've legit seen this picture like 6 times in this whole trial. I've watched the entire trial, right? They showed this to establish Thug throwing up YSL gang signs.
With all due respect, sometimes I forget how old I am today.
Bro forgets how old he is today.
I didn't have to count the years that I was born, sometimes to say my age today. I would never be able to tell you how old I was in none of the pictures. Oh, wait, I'm sorry, I heard you ask the same question.
Do you have the same relationship with Young Thug today that you had when these pictures were taken?
Yeah, you keep asking me the same question. No, I don't comprehend when you ask me that. Like,
Are you still friends with Young Thug?
2, 3, 4, 5, 6,
7, 9, there are 10 pictures right here, of you and Mr. Copeland. Is that fair to say?
I'm in some pictures by myself.
Somebody else is on this way, right?
Right.
So my question for you is, 164 Echo Hotel and 164 Echo.
He's good.
Hmm?
He's just extra.
Excuse me.
Extra. He's just extra.
He said, excuse me,
Yeah, extra,
denied
right?
the water, coughing in this lady's face.
I'm sorry, you take it?
No, I said, excuse me.
Okay.
I don't keep up with the days, the months, and all that. I go day by day. Is Lund and Gold the same?
Do you think Lonnie Gold is the same?
I want to just ask you about that.
Alright, it's a pretty painful day, but Woody's having some lawyer issues, firing his lawyer live on the stream. She said he did it earlier too, and apparently he can't even read. It's kind of embarrassing the way he's acting, but he's trying to be oblivious and not snitch as much as he can. Really similar to the way Tick testified, like very vague and acting dumb. Join the channel membership, I really appreciate the people that join the channel membership. It helps me not.
Basically, they wild. I'm gonna give y'all some more of this Young Thug situation. You seen that one? Let's see. I want to do.
Every week, millions of Americans are filling their carts with ultra-processed, low-quality foods, but it's not their fault. Hi, I'm Chris.
I'm not a lawyer, but even if you've stopped caring about the YSL trial, or maybe never cared at all, what happened today was absolutely insane, and you're going to want to watch this video. So let me tell you what happened on day 87 of the YSL trial. So this is a man named Kenneth Copeland, aka YSL Woody. And back in February of 2023, a 3.5-hour video of Woody talking to Fulton County investigators was leaked online, and he was in there talking.
So this guy had Quay Savage.
Which Savage?
Yes. It's crazy.
21 Savage?
No.
44 Savage?
Yes.
Okay. They're gonna do what?
They went to the club tonight.
Now, Kenneth Copeland's name has been mentioned a lot throughout this trial. He's been mentioned as being a member of YSL, as well as being present or a participant in a number of crimes, allegedly. But he was not included in this indictment. So of the 28 people charged in this RICO case, Kenneth Copeland has never been one of them. It's been rumored that he was one of the state's key witnesses for this whole case. And today, Max Sharp, one of the defense attorneys, even said it in a court.
Mr. Copeland is the key witness to a number of acts in this case. He's really one of the key witnesses to the case, if not the key witness. His credibility is the crux of this case. He's the linchpin of this case. I anticipate that he's probably going to be on the stand for a week or more.
All right, so Kenneth Copeland was supposed to testify today, and his testimony was supposedly going to bring a lot of stuff together for the state's case, but spoiler alert, that didn't happen. Before Kenneth Copeland is called to the stand, Ms. Hilton informs the judge that she has been talking back and forth with Kenneth, and he's been cooperative. But then last night, she received an email from Kenneth Copeland's attorney.
Your Honor, yesterday evening, the state received a email from John Melnick with Mr. Steele and Mr. Sharp copied on that email. Mr. Melnick advised that he represents our next witness in this case. Prior to receiving that email, the state had spoken with our witness on multiple occasions in preparation for trial. After yesterday, at about 5 or 6 p.m., whatever time I received the email, he advised that we need to cease all communications with his client.
His client is,
Mr. Kenneth Copeland.
okay.
However, his client is not, there's no open pending litigation. We were operating as a witness. The state did offer Mr. Copeland use immunity in this case, so that anything that he testifies to in this particular proceeding will not ever be used against him. And so we are ready to move forward. However, I did want to bring to the court's attention that Mr. Melnick did advise that he was his attorney and that he was present and I believe wanted to either address the court. But
So Copeland's attorney comes up to the stand, and he highlights that the Fulton County DA's office was well aware that he was representing Kenneth Copeland, and that he has had a number of conversations with them regarding his representation of Kenneth Copeland. Yet, they've chosen to only correspond with Kenneth Copeland directly.
Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton
He ain't
County
having
Office
none of
was
it.
very well aware
This guy right here,
that
he
I
ain't
was
having none of
representing
it.
Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday, and told me that, he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning, that apparently an immunity order has been entered, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations, and Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a call regarding bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker, and we very specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
So Ms. Hilton gets up to argue her side, and she basically says that Copeland said he didn't have an attorney, and that's why they didn't call Mr. Melnick.
We have only spoke to Mr. Copeland as it relates to his being a witness in this trial. Mr. Copeland was subpoenaed a few months ago, but as we were getting closer to his testimony, we resubpoenaed him again last Friday. When we met with him, we spoke with him briefly. I believe I asked him if he had an attorney or Mr. Melnick was his attorney. I believe my understanding from Mr. Copeland was that he hadn't spoke to him or that he wasn't his attorney. At that point, we continued to engage in conversation. Mr. Copeland engaged with us. We did not meet on Monday. On Tuesday, we thought that he was going to get calls. He came down here. We spoke. He asked us questions. We answered his questions, and we moved forward. At no time during any of those conversations that we had with Mr. Copeland that he advised that he wanted his attorney there. We would have obliged that, but I believe that we were having good conversation as he's a witness in our case. Yesterday, at our final prep session, we spoke with him. It was about 1 o'clock in the afternoon in the courthouse. When we left the room that we were meeting in, I saw Mr. Matt Shard in the hallway. As we left, we had our greetings. And then it was not until 6 o'clock last night that I received an email from Mr. Melnick, copied Mr. Shard and Mr. Steele on that email, and advised that his client was going to plead the Fifth. Once we received the email from Mr. Melnick last night, we moved forward, Your Honor, drafting a motion in order to give Mr. Copeland use immunity in this case. And we have decided that whatever Mr. Copeland says, he will have immunity. If Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well. And so the state would ask that Mr. Copeland he could have to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
All right, to make sure we're clear, Kenneth Copeland, without the presence of his attorney, signed and agreed to testify in exchange for immunity, with the understanding that him not testifying or him pleading the Fifth means he would be held in contempt of court, and that means going to jail. The judge calls Copeland to the stand to make sure he truly understands everything that's going on. And if I haven't said it yet, the jury's not in the courtroom for any of this.
Mr. Copeland, come on up and have a seat here, sir.
That's big.
Keep moving! Go!
All right, has the state provided you a letter of immunity or a copy of the order that I have signed?
Yes.
Let's just go through it right quick, okay? I just want to make sure that you understand where you are, and you have your attorney here, and if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right.
Okay.
Okay, all right. You've been subpoenaed in this case to appear before and give testimony in this particular matter. And the state has provided the court sufficient reasons as to why you are necessary as a witness in this case, because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case. The state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they want in this case, for you to testify. So your attorney told me you're going to invoke your Fifth Amendment privilege. Done said. However, the immunity's been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. You talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the field.
Okay, you're taking the fifth, but you got immunity. You still want to, are you going to testify? That's the thing.
That's the question.
Yeah, but the state don't know what they're talking about. So they ask me a question, they me, then
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That whatever you have to tell us, you tell us.
But not federally.
Do you wish to testify, Mr. Copeland? Is that no?
State, but not through federal.
say it again.
Do you wish to testify?
He said I tell him whatever I got to tell him. So I testify.
You will testify.
Yeah.
All right, sir. Okay, what we're gonna do in just a second is, I'm gonna go ahead and I'm gonna call for our jurors, potentially some.
My turn before, because I think I just said the wrong thing.
Sure. I'll tell you what, why don't you step outside and we'll talk to Mr. Melnick.
Kenneth Copeland goes out to talk with his attorney and then he comes back in.
All right, sir, what's your pleasure? Are you going to testify?
Yeah.
Okay, all right. All right, sir, then what we'll do at this point in time is, we'll call for our jurors and we'll swear you in and, we'll go ahead and take your testimony, okay?
The jurors are finally called back into the courtroom and Kenneth Copeland gets back on the stand to testify. And ciao.
Without further delay, we'll go ahead and call the next witness. State.
This is why I stay out of trouble. I ain't trying to see no courthouses.
All right, summon Mr. Copeland, please.
Craziness.
Hey, Mr. Copeland, good afternoon. Do you want to be,
Ma'am,
do you want to be here?
I'm here.
Okay. Well, you're gonna let me ask you some questions.
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you said you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? Room.
All right.
Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take them into custody.
Anyway, and this is what happened.
Did you hear the cups?
State, do you have any other witnesses you plan on calling this afternoon? No. Okay. What I'm gonna do is I'll call our jury and tell them that you're gonna be in recess for the weekend, and we'll come back on Monday.
Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now. And what's the basis for your mistrial? We didn't know he was gonna invoke. We didn't know what he was gonna testify to, and I certainly didn't let him. He was only asked one question, so at this point in time, there's really, I mean, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based on information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information,
Look at
but
the
I was told
prosecutor. Look at
that
the
Mr.
prosecutor.
Copeland made that known
Look at
to officers of the
He started
prosecution
talking,
team
this is what
prior
they
to
do.
being called right now.
Look at the
But
prosecutor.
it's what I was told. I mean,
Look at this one.
the last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of the jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Stacy, that's what we've heard.
No, so the jurors have heard Kenneth Copeland.
And as well.
I
Okay.
opened on him that he's the killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his
So they
response
start
was going to
moving
be, I'm
seats,
voting for
doing
Fifth
a bunch
Amendment.
of stuff when you
Your
start
Honor,
talking.
Yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial. Please.
Okay. Sorry, sir. Thank you. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has,
Your Honor, I'm just telling the court, I'm not accepting the proffer.
Your Honor, if I may,
Okay, but counsel gets the proper, Mr. Steele. I can accept that. So, could you sit down, sir?
The sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court, the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for
Dylan,
concern
not working with.
is
Somebody say
Mr. Copeland's
Dylan.
communication that
That means
he is going
aggravated.
to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants. After Mr. Melnick attempted to assert for Mr. Copeland, may I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right, thank you, sir.
Sit on
While Mr.
down.
Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does the any
Mr.
point in time tell
Copeland,
you, does the any point in time tell you I'm not going to testify? I'm gonna vote the Fifth Amendment.
no, as what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick, had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses, this particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks and after Mr.
I
Copeland
wonder how
has
she
communicated
sleeps
to
at
this court.
night, man. She
He will
gotta know all
testify.
these people's
The reason Ms.
names.
Hilton was not in here just
Gotta be all
now
up in
when the
their
jury came out is that
business.
Mr. Copeland asked to speak with Ms. Hilton. But
I
Mr.
wouldn't want
Melnick
that
kept
job.
going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interest he's representing. As to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state. So, Your Honor, I would ask that the court deny the motion for a mistrial.
I won't deny the motion for mistrial, Mr. Seal, at this point in time. I'll note that you've made it.
Let me interject to make sure that we are all clear about what's happening. Steele wants a mistrial because knowingly allowing Kenneth Copeland to get on the witness stand and plead the fifth is prejudicial against the defendants in this case. But Ms. Love just said essentially that Kenneth Copeland's attorney and the defense attorneys are in cahoots and trying to get Kenneth Copeland not to testify. So mistrial denied, but Brian Steele isn't done. He and Max Sharp have more things to say.
That in order for you to deny my motion for this is bad. And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time, okay? In terms of this motion for mistrial. Well, I'd like to call the
There
witness.
you go, there's nothing more.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine, okay?
I believe that the state was on notice that something like this.
Okay, all right. But all of you have kind of either unwittingly or from, I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this.
Both sides?
Do not let outside influences influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these witnesses will testify to whatever they will testify to. So
The defense has done nothing.
I didn't say you did anything wrong. Okay, but I didn't.
I've heard is state.
I didn't say you did anything wrong, but
But I understand,
Okay.
Your Honor, but I just want to be clear. The only thing I heard today is that the state met with Kenneth Copeland without his attorney. Because he.
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you, okay?
Okay.
All right.
But I would like to hear.
Yes, sir. What would you like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland concerning this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today.
Everybody just wants to be
I can
mad
assure you
right
that the
now when they get a
decision
chance.
to invoke the fifth came completely from Kenneth Copeland. I owe nothing to anybody over here.
You ever been around somebody and you can just tell they want to argue? He sounds like he's just been sitting there waiting all day, ready to argue with somebody. And the judge has to take all this in. The prosecutor has to remember all these people's names, has to get along with all these people. This is crazy. I was going to be a lawyer. Just imagine. Whew.
I owe nothing.
And my mother used to do that thing right there that the lady's doing right here. What the lady's doing right there. What do they call it? Stenographer?
To anybody at any of these tables, I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel.
You already said? Let me rewind that.
I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel.
She said, ooh, I'm telling on you.
Monday, we'll go ahead and call.
They gonna get a lot of calls
before the
about
jury
this
comes
freaking
in.
trial.
On Monday morning, we'll ask him whether
This is
or
why I
not
don't hang out
he
with
wishes to
people.
continue
This
his
is why I hang
testimony.
out with
I
all
don't want him to
these people.
invoke in front of this jury. If
You start hanging out with people before you know it, they start calling you a gang. Before you know it, you sitting in front of these people and your whole life is on trial. I'm good. No, thank you. You know what I mean? And that's when, you know what I mean? Now everybody's got to act like they're perfect, and everybody's not. Everybody's doing, you know what I mean, something. Everybody's got something. That's just life.
I can help it. So since he's made it once already, I'm going to ask him before
Back
the
to the
jury
trial.
gets out here on Monday, is your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
That's probably not true.
It is grossly unfair.
I've known you for almost 2 decades.
There you go.
I've known Ms. Hilton and Ms. Love in particular for a long period of time, and I don't think that they would do that to you.
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because.
When did you talk to
There she go.
Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had
Oh, that
told
would
Ms.
piss
Love
her
that he
off.
wasn't his attorney. So when we went to go serve
I
him,
bet you when she
then
go home,
advised
she
me that
fight.
He didn't have an attorney. When I met with Mr. Copeland,
But if she do, you ain't winning because you hear that voice? It's so strong, like, it's like very argumentative, right? She's perfect for a prosecution. But I mean, in real life, I wonder, like, if she has an argument with her man or whatever, how she's very like, ugh.
Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick is your attorney. He said, Mr. Melnick is not my attorney.
Her scooting over is sending me.
He said, I haven't even talked to her. And then that is when we proceeded to begin our conversations. Anytime Mr. Copeland did not want to speak with us, we did not speak with him.
She extra,
On
right?
Tuesday, when
Yeah, I
he
agree.
did not take the stand, we went upstairs, we had some conversation, we left. Mr. Long took him back home, and then
Don't ever
yesterday,
argue with
he
this
came
lady,
back down
okay?
here with us.
Don't you
Again,
ever.
We showed him some of the evidence that we were going to show him, and that was.
And
the
she
extent of it.
gestures,
And
too.
anytime Mr. Copeland would have told us he wasn't his attorney,
She been in church.
we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So
Okay.
that is what I based all of my decisions
Okay.
after. It was
Snap
not
your
until
fingers
6 o'clock
after,
last night, whenever
sister.
the email was sent from Mr. Melnick with Mr. Shard and Mr. Steele's copy on it, that I get this idea that you've been talking to my client, and then my client is going to plead the fifth, which brought us here today. That has been what has
Snap your
happened for this
fingers,
Friday.
sister.
And
Oh, and one more thing.
Mr. Melnick called Mr. Copeland last night. So it wasn't even that Mr. Copeland called Mr. Melvin. Mr. Melvin
she
so
mad.
happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
Okay,
So I'm not
let
gonna
him
get into
know.
my conversations with my client.
No, and I don't expect you to.
Snap
That's
your
where we always spend
fingers.
Time is that Monday morning, I will bring Mr.
Look, she
Copeland
mad. Look
back
at her.
out.
She can't even
It
hold
is,
it in. Look
I
at her. You wanna go
don't
close?
relish the
She
fact
mad,
that
look.
we're in contempt, but
She
that's all I have
mad.
at this
Look.
point in time because he's been given immunity. So
Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial. Because
Which could
I'm
be
certain
forever.
Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there's
Don't get her
nothing that we
mad.
could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's
I like
order.
her. Miss
Under the
Love,
statute
I
the
like
court
her.
decided 24
She fight her heart out.
And
I like that
statute gives the court
prosecutor.
the
She make a
ability
person like me don't
and-
ever want to get in
probably,
trouble.
you know,
Because I would never want to go against her.
Duty, given
Her name
the
is Miss
necessity of Mr.
Love.
Copeland's testimony to
Come on.
hold
Her name is Miss Love. And she fighting out there. You can tell she's fighting for her city. She's trying to get rid of the craziness on her city. And she fighting. You know what I mean? Gotta give it for her. You know what I'm saying? She's fighting for her community. This lady right here. You gotta give it for her. When I was young, I would have been like, man, screw this lady. She's a prosecutor. But I see what she's doing. I see the passion. She up there every day. Like, yo, I'm gonna take this whole set down. Y'all destroying my community. And watch what she do.
Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or
fighter,
another member
boy.
of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those
Which could be
matters
forever.
to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Y'all heard that? If he doesn't testify, he will be held in jail until the end of the trial. And don't ask me when this trial's supposed to end, because nobody knows.
okay, I'm going to recess in just a little bit, and can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session
Life.
of court.
Life,
Judge,
you
I have
always have a choice in
non-refundable
life.
tickets.
Hear a judge say I don't have a choice. Whoa.
No living being.
You always got a choice in life,
Processed
Judge.
food
Your
for
Honor.
every single meal of their life.
Always got a choice.
Real food is
So I gotta
simple.
find
It
no
looks
more.
like
Hold on,
food.
guys.
It smells like food. It's what
Right? Always got a choice in life.
It's so real.
One thing, always remember, guys, that's one thing about it. We always got a choice. You might not like the choice, but we always got a choice. For anybody ever tell you, I have no choice. No, you always got a choice, okay? Remember that.
Out of town on Monday. I can't be here. I cannot be here. And there's nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this tricky position.
I can't be here, Joe. I absolutely cannot be here.
You have
You have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. He's coming back on Monday.
I'll have somebody else make my.
Then that can be done, and sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that, so we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is.
I'll
And I need to know who that lawyer is. Some of our jurors, please.
So the jurors are dismissed for the day after hearing about 2 minutes
said,
of
"Man, I need a
testimony,
vacation."
But the day isn't done yet. Miss Love tells Judge Glanville that Brian Steele was supposed to turn over some files for some jail calls to her, but what he sent over instead was incomplete, making it so that her and her team couldn't play the calls. And according to Miss Love, Brian Steele did it on purpose.
Any other things I need to consider?
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received something additional on a thumb drive last night.
Miss Love starting to grow on me, young thug, man.
And we are again missing, we do not have the complete file
To be able to play
to be able to access it properly, to be able to look at it, authenticate the calls, the time, all of that. We don't have it. We were provided last night a thumb drive with with cut and
Sketchy
pasted
stuff.
file names up under headings, with some additional
Made it
pieces of a file
complicated.
that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We
Table
are asking the
remembrance.
court to compel defense counsel to turn over to the state the file in the condition, in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what, and if they don't want to, then we're asking that they just be excluded.
And Brian Steele gets pissed.
Judge Lamb, sir, you allow another moment when Ms. Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation, just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful.
You start coughing when you start talking right.
I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia.
Watch how many
I've
coughs.
never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8 after 8 last night. Waited for their investigator to come by. I handed him an exact copy of thumb drive. They had everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time. And I apologize that I'm getting tempered. But I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't like coming to court. I used to love it. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Ms. Love, I would.
Your Honor, can we strike no comment and no I'm speaking?
She don't want to hear that. She don't want to hear that. Leave Miss Love alone.
Everybody, both of you sit. Both of you, please.
Leave
be
Miss
seated.
Love
Judge,
alone.
both of you, please be seated. You have to do something. You have threatened me with contempt. You have threatened me with.
Oh no, he ain't threat. It's
If you
coming.
go back in time, we can just start the voir dire.
Now you done made his colleague mad.
Voir dire painful. Ms.
Shouldn't
Love
have
would
did
come
that,
in
Mr.
and say
Steele.
that juror was crying. It was not
That
true.
was
You
the
said
R.
that's not my
Kelly
recollection.
making
That's what I said.
Jay-Z
Did
mad.
nothing. We start the case.
Mr.
I
Steele.
asked you, please.
Mr. Steele.
How would you feel if you were being treated?
Mr.
Probably his sister
Oh, I'd like to
coming
finish.
on.
Mr. Steele.
I gave him everything on the drive, and it's.
And this is why he's went to jail. It ain't because of the other thing.
I don't talk with Ms.
It's
Love.
because of this.
And that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, I'm not, listen.
They will take
But
it.
there,
And Mr. Williams, you know, to me, this is an innocent man. You talking about, Ms. Love said, there's a man in Fulton County Jail, he shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to, that Ms. Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw. Now it's Mr. Wall. All because she wants to win the case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case, it's gonna take a long time, give them things. I gave this, by the way, to the state, October of 2023. October 2023, that was uploaded. Give it to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it. And you have told it in front of the jury, I'm unprofessional, you were wrong. You based that on Ms. Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor, I object, and you should stop talking when I object.
Stop talking. You heard me, Judge. That's all right.
Silent, or were you silenced?
but Mr. Steele, here's the thing, okay? I think that, Mr. Steele, please be
Gosh,
quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated.
Whatever you do is fine.
That's it.
I care about Jeffrey Wood.
Respect.
It's obvious, sir. It's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. I know that time tempers have been
That's what
heated in
millions
this
do
particular
for you,
trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that there should not be ad hominem attacks on anybody or any counsel.
and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial. And I mean, and so not only for the purposes of this, but it sends not the message I think you want it to send. All right. So I'm going to leave you all to your wise discretion in order to do that. But I'll take up whatever I need to take up as I see fit. But I know that you all, this has been a long trial. It's very demanding, exacting, and grating on and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see and kind of look at and just remember that you do represent of who you represent and what you're here for. It's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that. Let me do a notice to produce or rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you because nobody probably wants to come down here and see me. But I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. You're all going to see each other over and over and over again. And, you know, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. Counsel, is anything else I need to cover with you before we recess until Monday? Yes, Mr. Botts. Mr. Botts, you need to use the microphone, sir.
Yes, they still had more to say.
Is it working now? Can you hear me, Tom?
Yes, sir.
All right. Your Honor, we started this whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to...
You have to speak up, sir. And if you could hold the microphone, it'd probably be better.
He was going to assert the Fifth. And I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. They even said, the officer...
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele...
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my...
I got a problem with you now.
Well, that's fine. I mean...
No, I got a problem with you now.
Well...
I would suggest you don't say anymore.
I've already said it.
I know that, sir. And the problem is you should have told me, if that were your case, then you just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer. Now you want to have it both ways? You can't do that.
Your Honor, I thought the state knew that,
and that's not what the point is. The point is, you as an advocate, is you should have told me. Both sides have an equal responsibility under the rules of professional responsibility.
Exactly.
Okay, as long as we're both responsible, that's fine.
All right, have a seat, sir. Thank you.
Is that okay?
No. What's your question?
So in the attempt to avoid any spurious allegations
You
moving
don't know.
forward,
He always
I
get
would ask
denied.
that Your Honor order that the deputies transport Mr. Copeland to the jail completely separate from him.
Yeah, thank you for reminding me about that. In our order, wait just 1 second. In the order of the incarceration, I'm going to also have a keep separate order for him.
For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that he did.
I think that's fair enough, and that's a good suggestion.
So the order was put in for Kenneth Copeland to be transported and housed separately from all of the defendants in this case, and he will be back on Monday to see if he's going to testify. And so court finally wraps for the day.
Take a couple deep breaths this weekend, take a knee, and come back on Monday and let's get after it again, okay?
I imagine Monday is going to be complete chaos.
Wow. Crazy.
And when I'm written out,
Crazy, right? So you get to see what I be saying sometimes. Wow. Yeah, he really arrested this dude.
How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question.
and I'm
How did you find out about it?
Mr. Copeland made statements that he admitted to killing Donovan Thomas. Don't take my notes. No. Take Mr. Steele into custody, please.
No way, dude. You're watching a part of history right now.
Okay?
I believe that the court has put him in that position.
No, he purges himself of the contempt.
That's civil. He's not getting that civil.
That's civil
That's civil.
Respectfully, I would
The Young Thug Lifestyle RICO trial was spiraling out of control. Brian Steele points out evidence of coercion and witness intimidation by the judge and the state. The judge freaks out and asks how he found out about an ex parte conversation with the DA, a witness, and the judge. Steele refuses to answer, and then the judge sentences him to 20 days in jail over the weekends. The judge is straight up wrong here and didn't want to admit it. There's hundreds of defense lawyers citing case law, I'll show you at the end of this video, and over 25 defense lawyers came to Brian Steele's defense within hours of this happening on stream. Once again, I'm left speechless. I don't even know what to say. Just watch the full video. Hit subscribe. Here we go. First look at Thug on day 88. Got the clean knitted sweater on. Looking good, looking good.
Mr. Copeland's had the opportunity to speak with his lawyer, and here's my understanding he's going to testify. That's the latest I can give you, okay?
Ah? What, he's testifying now? A weekend in jail with some bologna sandwiches changed his mind.
Sir, it is your intent to testify today, is that correct?
Yes.
Okay. All right. Some of our viewers, please, Sergeant.
I wonder what changed his mind.
Jail, maybe?
He's already being difficult to state. Whoa, the state is getting a wireless microphone put in her hand now. Thank God.
Are you from Atlanta?
I'm from Canada.
Okay. Is that a section of the city in Atlanta?
I guess.
Yeah. Did you grow up in Mechanicsville?
For sure.
You said for sure? All right. And what are your three brothers' names?
Trey, Nato, Boss.
Say that one more time. You said it fast.
Nato, Trey, Boss.
Nato, Trez, and Boss.
I went to a lot of different schools.
And what are all the schools you went to?
I don't recall all of them.
When you went to high school, did you go to Southside?
Yeah.
And how old are your two children?
The same age.
Prior to any of this, do you have any criminal convictions?
Of course.
Okay. Do you know offhand how many?
Don't keep up with it.
There's a big stretch from Thug. Hit the like button for the stretch. It's intense in here today, dude. With Woody on the stand, it is very intense because of what happened on Friday.
Do you recall having a federal gun charge in 2015?
You asking me or you telling me?
I'm asking you.
What you asking me?
Did you plead guilty to a federal gun charge in 2015?
I think I did.
Did you get out of prison and then go to Rice Street?
Y'all locked me up so much, I can't really.
And let me say this, when we say Rice Street, are you talking about Wilson County Jail?
I know the setting of this whole situation is not funny, but I can't help but chuckle when some of these guys, like the way they answer questions.
I got it feds in 2019.
In 2019? Okay. Ms. Coleman, do you have a nickname?
Yep.
What's that?
Woody.
Do you know someone by the name of Shannon Stillwell?
What's his nickname?
SB. Or Shannon?
Come on, bro. He's in the courtroom. You know SB. You were friends with him.
Yeah.
How long have you known Shannon?
We went to school together.
And do you see Shannon in the courtroom today?
But I got a vision problem.
Okay.
I can't see that far.
I got a vision problem. I can't see that far. Clearly a lie. I don't know why the state puts up witnesses they know are going to be difficult. It kind of makes them look bad.
Do you want to stand up and look around the courtroom and look around the entire courtroom, tell me if you see Shannon in the courtroom today?
He's to the left, bro. This is amazing. The silence.
Do you need to sit down?
Nah, I ain't having any drink.
Okay, do you want some water?
You gonna give me a drink?
I'll get some water.
I don't drink water.
Well, I don't have nothing else for you. But I will put some water up there for you.
I don't drink water. Pretends to pass out.
Who am I looking for?
Shannon.
This is insane.
I think I see him.
Okay. Well, you say you think you see him. What do you think he's wearing?
Look like he wearing gray over there.
So who are you pointing to over there that's wearing gray?
I think he got red hair.
Okay, so you pointing to a lady and not Shannon?
The one behind her.
Okay, so you're saying you believe that the person behind the lady with the red hair is Shannon. Is that what you're saying today?
But it looked like.
That's not Shannon Stillwell right here. So he's intentionally pointing out someone that isn't Shannon.
Does anybody else over there look like Shannon?
Yeah.
Okay, who's the other person who looks like Shannon over there?
He's standing behind the bald head dude right there.
He's standing or he's sitting?
Sitting down, I guess.
Okay.
But it's funny because the bald head of the lawyers keeps being brought up every time they identify someone.
Bald head.
So you're saying Shannon's the one with the bald head? Or he's sitting
No, he's
behind
sitting
him?
behind the dude with the bald head. I think it's him.
Okay.
Hey, two people with dreads. I can't see. I just see dreads.
While y'all were in school, did y'all develop a friendship?
Nope.
At some point in time, did you ever develop a friendship with Shannon?
Yeah. At one point we became cool.
Okay. And when you say cool, what do you mean?
COOL.
I didn't ask you to spell it, I asked you what you mean.
Well, we became cool. I don't know what you mean. I don't know. Oh, just a dude in the street.
You never met any of his family members?
I never met none of his family members.
What about any of his girlfriends?
What you mean?
Would the two of you go out?
I go out with anybody, even you.
I'm not asking about me, I'm asking about Shannon. Would the two of you go out?
We have one out.
Okay. How often have the two of you gone out?
I don't know. Well, I've been in jail most of the time, so
Did you all speak while you were in jail?
a few times.
So your friendship didn't stop just because you went to jail?
What you mean?
Did your friendship stop just because you went to jail?
Who
Or
determines when a friendship start and stop?
I guess you would.
I will.
So did your friendship stop? Or your coolness, because you said coolness, did your coolness stop with them when you went to jail?
I don't. Hey, Judge. I'm hot. Can I take this foot off?
That 5-minute break turned into 25 minutes. Brian still has something to say.
Pursuant to the 6th and 14th Amendments of the United States Constitution and the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts, I was told based on information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived. Supposedly, in chambers of Honorable Court, Honorable Court at times, district attorney or district attorneys, the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on.
That's not allowed, right? There can't be an ex parte conversation with the judge, state attorneys, and a witness. What?
They were told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based on information and belief, that the lawyer for Mr. Copeland and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm not disturbed too. And the reason...
Well, I'm asking you a question.
And
How did you find out about it?
I'm going to ask you a question.
Okay.
The judge is shitting his pants. I think the judge realizes he's caught here with something he wasn't supposed to be doing. Wait, how did Steele find out about this? It has to be Mr. Melnick, Copeland's lawyer.
Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based on what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me.
But there was a witness there.
Those were ex parte for a lot of different other reasons, but certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
How
going
did
to answer that question.
You're not?
No, I will not answer that
Why
question.
would you not answer that question?
Because I want to make sure that what I say is accurate. I'm not trying to...
I'm asking you, how did you get this
I'm
information?
not telling the court. What I'm saying based on information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this... I have problems right now.
Okay, I know, look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? If the case gets reviewed...
I don't want to hear about your problems.
To be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me.
But there was a witness.
Those were ex parte for a lot of different other reasons, but certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not
How
going
did
to
you...
answer that question.
You're not?
No, I will not answer that
Why
question.
would you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
I'm asking you, how did you get this
I'm
information?
not telling the court. What I'm saying based on information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this... I have problems right now.
Okay, I know, look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? If the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party.
A party?
Yes.
A witness who was sworn in Friday? The court's telling this is what...
Yeah, that's what I was just saying. A sworn-in witness shouldn't be involved in an ex parte conversation.
But I was told, if this is not true, not true. This court handed Mr. Copeland...
Tell me how you got the information.
Listen, tell me what you do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly, that's this honorable court.
Okay.
Or excuse me, let me rephrase that. This court supposedly said, I can...
You changed it from audible court to court. You took out the word audible. This conversation could be why Kenneth Copeland is testifying now. Wow, insane. This is gonna be a mistrial. This shit's gonna be over, dude.
Hold you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants, and then all 26 people are disclosed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who that. Tell me who this
I
information
don't
is
want to
coming
be held
from.
in contempt.
Well,
I'm not
then,
answering that question. That's attorney-client privilege information. I am not...
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I tell
telling
you what,
you...
I'm going to give you 5 minutes. If you don't tell me
Don't
who
have
it is,
to. I'm
if you
gonna-
don't tell me who it is, I'm going to put you. I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not...
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not... You should have told me. You got 5 minutes. Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas. Don't take my notes. No.
The deputy tried to take his notes? This is literally a TV show. He said Copeland admitted to killing Donovan Thomas.
Okay, Mr. Steele, would you take the podium, please, sir?
The judge's dog is barking behind him. If you didn't know, the judge has a dog behind him at all times for like PTSD. I believe from being in the army.
Mr. Steele, before I recess, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again, and I respect that. And it gives me no joy, as you know, Georgia rule professional conduct. Please check me. 1.6. I know what the rule says, but here's the thing. Well, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held in contempt.
Or you can't hold a defense lawyer in contempt that takes the defendant's right away to have counsel, right?
I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raised it. It's that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Stay out of the courthouse.
Why would it be ex parte?
It's ex parte. No, it's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked the Samba court or any court to meet with me and a witness.
Adding the witness in there is the issue. That's the main issue the judge is ignoring. He's more focused on how it got told to Brian Steele than the main issue.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you.
The privilege in 1.6 would occur if you were in the right place, right time to begin with.
To give you information, and you're saying it's not some substance, but I'm telling you, I can't do that under the bar rules.
All right, well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are. Let's stand on that point, because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not sure.
I don't want to hold you in contempt, but if this is that serious,
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, and listen, I'll do whatever you want. This is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief, from part of it.
From whom?
Well, I'd like to get the substance first, and then we'll get.
Okay, well, then you'll be in custody until then.
There's no way he does this. There's no way he puts Brian Steele in custody.
You need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, shared that information with you, she probably violated privilege.
Well, I don't know how that was a privileged communication. It shouldn't have been.
Well, because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have
When I got this information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's really it.
You need to go into custody at this point.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day.
But why?
Okay,
Why
that's for another day.
in the first place? I didn't know about this.
That's for another day. So
I raised it as soon as we found out about it.
Well, this trial's over. Something's going to happen in the next 24 hours.
You should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the
court has said, it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal. Mr. Steele. But you're acting like it's Mr. Steele. That is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asking to hold. You're not supposed to have communication with a witness who's been sworn. You know, I'm not telling you, I'm just saying if you read it, I'm assuming you read it. That's what it says, and you did it. You said it supposedly, and what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we can really understand it. I'd be breaching 1.6, and I know you're assuming something. I don't think you're breaching 1.6. You can't hide behind 1.6. I'm not hiding behind anything. You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it. What I got, unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So, Your Honor, but that's the issue, isn't it? That needs to be told, but we don't know why we were excluded from that. Mr. Steele, and I want that information because Mr. Williams' constitutional right, it's Georgia Constitution. Stop at this point in time, because Article 1 says you already said that. You've already said Georgia Constitution, and we have the right to be present. All right, Mr. We're not waiving any. Yes. No, I said this previously. Yes, sir. But we are not accepting any proffer from the state.
Excuse me.
Oh my God, Brian Steele is such a G. Why was a sworn witness talking to the state and the judge, and then now suddenly he wants to testify? Isn't that f***ing insane? I'm seeing so many defense lawyers on Twitter like freaking out over this.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt imposed upon a person for not obeying the court's directive. We believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statement is in regards to my representation of Mr. Williams. He has two attorneys.
Okay, yeah, he does, but
the court, now having found Mr. Steele in contempt, that the court continues in that position.
The legendary Keith Adams, here we go, man.
That leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court is engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. I am asking for in this trial. I do not believe that we can proceed at this point based upon the information that we've received. And frankly, I don't believe the state has any say in that. My statement is in regards to my representation of Mr. Williams. And if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that.
On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost.
All the defense lawyers coming to Brian Steele's aid here.
8:30 for a 9 o'clock start. Did not start till approximately, I'm estimating
I like
11
him
o'clock.
too.
We figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remained in the dark. I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple of days. But I will say, Your Honor, what I do know, just based on what we've heard over the last 20 minutes, it appears there was a meeting, knew nothing about, that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present. This was a critical stage in this trial. That error is a foundational, structural error in this case, and it is the cause for an immediate mistrial. I'm going to ask for the transcript, and I'm going to ask for the recordings as well.
I'm honestly speechless. I don't even know what to say. This trial is over. I don't know how it's going to go on after this.
I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied.
It's denied immediately.
Okay. Mr. Steele, last night.
Deny everybody.
Who told you? All right, Mr. Steele's in custody, and once he clears the area, we'll go ahead and get started.
No way.
Yeah, we're going to continue. I'm not calling nothing. You don't have that luxury at this point in time, sir. You don't. Really getting yourselves cross purposes at this point in time. Sir, I'm telling you,
You are at this point in time. You've made some things out of nothing. I think that you're on very precarious ground at this point in time.
You're the one that had a meeting with the sworn witness and the DA.
I'm telling you at this point in time, he's in custody. We're gonna go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not gonna take it up right now. You're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was said, whatever, this morning. But sir, I don't even know, your co-counsel won't even tell me who said whatever. Okay? And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No! It's not, sir. Sir. That's not what happened.
Judge, respectfully, we are not obligated to simply accept that there has been no violation. We believe that there has been.
Okay, well then you made your.
Crazy. It's happening, right?
Take Mr. Steele into custody, please.
Wow. No way, dude. You're watching a part of history right now.
Seriously. And that's why, this is why I got this live, guys.
Confer with counsel regarding the
Seriously.
Okay, all right.
Right in front of your face, history.
Oh my God.
Well, a lawyer is getting arrested.
Yes, sir, you certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will and my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other one. I denied your motion, but I'll certainly take that under advisement, sir.
Oh my God. Steele is a G. I wonder if Thug realizes he paid for the best possible lawyer. This is a scripted TV show.
Continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But
there's no way that's gonna happen. There's no way.
Mr. Steele put himself in this particular position in terms of all these. I'm not asking for any other information privilege or any other conversations, but I need to know who told you.
That affords Mr. Williams the right during these proceedings while court is in session, both of his counsels, for Mr. Steele to be present in the courtroom. He can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session.
So Miss Love wants Mr. Steele back too. I think Miss Love is doing this because she's terrified of a mistrial.
Court's remedy does not affect his ability to have his counsel of choice. There was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom.
So she's saying there wasn't really anything said in this ex parte conversation. Apparently there's a transcript of it, but I mean, how can the defense just take their word for it? That's insane.
All I'm asking for is some sunlight to come over these.
Sir, this is not an open meeting. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me. Certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But
we are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. Exactly. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Let's get Mr. Steele out, please. You can put his tie back on.
Put his tie back on.
I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of the today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying he was not going to go forward without having you present with him.
Order the transcript, we can see it and have a hearing.
No, I'm not going to order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. That's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. You're running a very thin professional responsibility. I don't think you have coverage at this point in time. I think you're blowing your coverage at this point.
So are you, brother. Dude, I feel like they could get a transcript of the conversation within 20 or 30 minutes, have the lawyers look at it. If it's nothing, then it's nothing, and we move on.
But you're indicating what was said. I want to know who told it to you.
And I'm making it based on information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time. No. Yeah, I'm holding you in contempt because you won't tell me who. How can something be obstruction? How can something be a very high privilege for the court? Well, because if somebody's a represented party and they disclose information that to you all as parties in this case, that could be a problem. That could be a problem. That doesn't make a difference, but you got information that you shouldn't have had. And then you turn around and say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was, is a material, part of the trial.
It's not, well.
Oh, wait. So you're saying this conversation is now a material part of the trial, which makes Judge Glanville a witness requiring him to be recused.
So witness testifying who met with the court and the DAs. That doesn't concern us,
Your Honor,
meaning the defense.
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna continue to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will. You have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. If you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then I'll in terms of what, sir?
I suppose contempt.
Yeah, it's criminal contempt. It's just like a criminal contempt, sir. You don't get to appeal from this.
Criminal contempt? I thought this was civil.
You will go into custody at 5 o'clock today, or whenever we finish, if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to this particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately. Like I said, I'm not looking to hold you in contempt. I really am. I'm not.
I'm seeing on Twitter right now that the judge apparently doesn't know the difference between criminal and civil contempt. Civil is intended to enforce compliance with a court order. A person alleged of being in civil contempt is often described as holding the keys to the jail. He just told Brian Steele that, but then said he's in criminal contempt. Criminal contempt is intended to preserve the power and vindicate the authority of the court, or in other words, punish those who violate court orders because there's no other remedy available. Judge Glanville doesn't understand that civil contempt has a remedy to coerce compliance with the court. Criminal contempt requires a punishment. Certainly appears he doesn't. So, Judge Glanville is in the wrong here. Okay, we're just going to proceed with Copeland testifying.
I recognize myself.
Okay, do you recognize anybody else at 358?
Myself.
Do you recognize anyone else at
They faces covered up.
Okay, do you see someone face who's not covered up at 358?
Yeah.
Okay, do you recognize who that person is?
I can hardly tell.
Okay, is that Shannon Jackson? Your Honor, at this point in time, I'm trying to impeach.
Deshard said she's showing him altered photographs.
Me, Shannon, DB.
So she's trying to impeach him by just showing relationship with him and SB, and he was acting oblivious, I guess.
But does that look like the three of you, DB and Shannon? Does it look like y'all?
I just said yeah.
Okay.
I can see, but I can't really see their face like that.
Okay.
I can't really tell who they're waiting to.
Is that Shannon Jackson or Shannon Stillwell?
Now they do got USA.
Alright, so is this your testimony that that is not Shannon Jackson in this picture?
I like to say I can recognize me. With the hat on.
Okay, there's three people with hats on. Which person are you with the hat on?
With the writing on my shirt.
Okay. What does the writing say?
DRC, third YRC.
What does DRC mean?
DRC.
What does it stand for something?
You asked me what it means. DRC.
Okay, does DRC stand for something?
Not to my knowledge.
Okay. It does stand for the robbing crew.
I'm not Rob.
Okay, that's fine. I'm asking you what does YRC stand for?
YRC.
Yes.
This stuff don't have no meaning. That's how I got this shirt.
Oh my
That's your testimony
god.
to that. That neither DRC or YRC mean anything.
That's how I got the shirt.
Okay. And then you said you recognize Shannon in this picture. Where's Shannon?
With the blue on.
With the blue hat on, the New York Yankees hat?
He in the.
And is that Shannon to the right? Or to my right?
It looked like Shannon.
Did you talk to him about your secret? Did you confide in him about life, things that had happened?
Now my seat go to the grave me.
Okay. Of the Medion Garlington.
Street name.
Little D.
For sure.
I'm sorry, say that again?
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury what you mean by that.
I mean, he's my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard him. I know when DB died, this when I took him in.
Do you remember what year DB died?
I don't remember when DB died.
Okay. So was that every day? Was that once a week?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
What time?
Until you answer the question, I'm gonna have to ask you again. So was that every day? Was that weekly? Was that monthly?
I don't know.
Did you consider Little D like your brother? I know you call him your son, but did you consider him like a brother?
I consider him my son.
Do you recall ever telling any detectives previously that he's like a brother to you?
I probably did it. I ain't no telling.
Okay.
These boys hanging out on the block with 30 deep shirts on.
Did you see him on the step in a white t-shirt and blue jeans and black and gray sneakers?
Yes.
Does that look like Little D?
I guess.
Was someone you call your son? Does it look like a person you might be your son?
Yeah, I just told you that from the beginning.
What, if anything, does what you're doing with your hands symbolize, if anything?
A bird, because I'm from Canada.
Is that the symbol from Mechanicsville?
We represent a bird. I want him to lie to me, and he wouldn't.
Okay.
And the police was accusing me for stuff. I went to the D and told him what I wanted him to tell the police, and he wouldn't tell the police that, so I got mad at him.
Okay.
Me and Shannon was friends, but me and Shannon was not together on the street as much as friends. We was not together a lot.
Okay.
It's been like 2 or 3 hours since Brian Steele was officially held in contempt, and now Judge Glanville's worst nightmares happen. An Avengers Endgame level of attorneys accumulated outside the courtroom waiting to stand in solidarity with Brian Steele. I'm not joking. Apparently like 20 defense lawyers have pulled up to the courthouse to defend Brian Steele. Like known Atlanta defense lawyers, and apparently this lady right here is named Ashley Merchant, and she is one of them. Part of the Trump trial too or some shit, so let's go.
That you figured out. Somebody told me this information, and you somehow said it is privileged, which I can't imagine. Or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. The lawyers are not allowed into your courtroom. No, we just
Or they're not in the court.
we just don't have any space, Mr. Steele. We can let in as many as we possibly can, and we'll fill up our benches at this point in time and we'll violate our security protocols. Do you have an attorney that's here for you, sir?
Ashley Merchant is here, she's the president.
Okay, all right, well, we'll let Ms. Merchant, that's fine.
You know, Glenville's sweating hearing that name.
I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, who told him that? He will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, it was criminal contempt. I told him what contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said.
I think Ashley's about to school Judge Glenville on what civil versus criminal contempt is.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list.
Oh,
And
no, criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him, plus he's had all day to tell me who it is. A little different, Ms. Merchant, I won't disagree with you, but.
Well, and Judge, just for the record, it's, that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require refusal. You actually have to sui sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
that is one of the cases. Also, two other cases. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is on state allegations, as I told you.
25 lawyers pulled up like the fucking Avengers.
There's room in the jury box, and then there's room in the courtroom, so we would ask that they go
I
out.
don't want you to do much, okay? No.
And at this moment, he f***ed up. The judge is realizing right now that there's case law.
The trial has continued. It has not stopped this trial. For you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
Oh, I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. That's a problem. That's a real problem.
Mr. Steele has a right to make a motion like this. If there were
He does.
But
I'm not saying anything, but he's kind of put himself in a particular position he's in.
no, Judge, I don't agree. I believe that
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No,
He
I believe that Mr. Steele, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but.
That's what you want, but that does not conflate to contempt. Your desire for him to answer your question does not mean that you have the power to hold him
So
in
you can
contempt.
come into court, Mr. Merchant, and not answer a question of the court, and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and we can't threaten him with contempt for presenting a motion in good faith that he believes there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you are part of them, by nature. And you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. Eavesdrop, which I don't believe he did at all. I don't believe that for a minute. I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned
I
it.
think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information.
I'm just sitting here speechless. I can't even believe this is real. She's like, he schooled this man.
I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness, necessarily. It cannot be an ex parte proceeding without you being
I saw that on Twitter earlier. This requires him to be recused if he's a witness.
a witness to this. So you are a witness to this proceeding.
Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case.
The judge kept saying it's criminal contempt.
Those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge.
Oof. Oof.
And he has the right to subpoena witnesses, he has the right to an attorney, he has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing, where he can call you as a witness. You can testify. You are necessarily a witness. For it to be ex parte, you have to be a witness. It can't be both ways.
I'll let the appellate court decide that. Anything else?
No, we'll file a notice of appeal, and we
Well,
have the order reduced in writing.
I'm gonna do that right now.
And Judge, you would ask that you grant the bond at this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt though.
You can grant him a bond.
No, you don't get one on that.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in,
Just the case law on that.
hold on.
More case law that shows he can give him a bond. I think the judge is scared of switching his ruling here. It sounds like he's scared of admitting he's wrong.
Criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
Criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
His contempt is, as long as he, when he tells me what the basis of the conversation is. I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
That's civil. He's not getting that civil.
That's civil contempt.
That's civil.
And that's the, respectfully, civil contempt imposes punishment as a means of coercing future compliance with prior order of the court.
Awkward as shit.
Prior order of the court presumably is that you direct Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk.
That takes away the whole point of criminal contempt, and that is, you do something, the court tells you to do something, order the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, or unethical.
So Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond. I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about this a second, okay? I'm gonna take 5 minutes out, I'm gonna think about it.
You got schooled by Ashley, bro. Alright, so this 5-minute break turned into over an hour. So the judge took an hour. Will he change his mind and admit he was wrong? Here we go.
All right, thank you for your patience, counsels. The court had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well. Then I stand next to your attorneys. I've made a clarification to the order of contempt. Mr. Steele, I am going to hold you under, still hold you in summary criminal contempt for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m. Subject to further order of this court.
An absolute travesty. What a coward. He couldn't admit he was wrong.
I'd ask that I can be with Mr. Williams and work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams. If that comes to pass, my support, I will talk with our sheriff and we may be able to make that.
No way Steele just said he wants to be in the same cell as Thug. I hope Thug realizes he bought the best lawyer he could buy. Steele is saying, let me be with my fucking defendant in the same celly, baby.
That's right.
Holy shit.
Money
If that
talks.
should occur, okay?
Funny tweet I just saw on Twitter, dude got sentenced to 20 sleepovers with Young Thug. These two G's right here about to be cellies.
Yeah.
I have to prepare
You
for my
get to chill with
cross-examination
you get to chill with your lawyer.
in
Money
the next
talk.
few evenings, and I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not gonna do that, sir. Not at this point in time, respectfully.
What?
Your Honor, respectfully, and if it's not released by the time that we cross-examine Mr. Copeland, our defense will be hindered. And
Sure, that would be an issue you can certainly raise then and now, but because of the way it was disseminated.
Supposed admissions Mr. Copeland made about our case outside of presence, and based upon information in the Lilly court, handed Mr. Copeland allegedly the law of false swearing and perjury. And if that's true, I'd like to also talk with him, if you'll call, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information.
And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients. We are certainly a party.
Okay.
And we were denied the right to be present.
All right, thank you, sir. I'm still gonna deny it. All right, anything else?
What an absolute travesty. I'm gonna go through some tweets here for you guys to understand a little bit better. So Andrew Hughes is a really good lawyer. Let's go through some relevant law. First off, judges are not supposed to talk to parties without opposing counsel present, except in a few limited circumstances. Judges shall neither initiate nor consider ex parte communications by interested parties. I'm not aware of any rule that permits a judge to meet ex parte with a witness. He cites a case right here. But talking with one party present, not notifying anyone else, and having a conversation with a potential witness about whether he would testify seems far beyond that. At minimum, Glanville can't hear the recusal motion. If the recusal motion is heard, then the sort of denials that Glanville has been making, in which he inquires instead about how the defense attorneys found out about the communication, can be an independent basis for recusal. Just keep citing cases, bro. As for whether Steele can be put in contempt for refusing to answer the judge's question, I'm dubious. While Steele argued that the communication was confidential under Rule 1.6, he was repeatedly interrupted by the judge and may not have been given a full opportunity to explain why he should not be held in contempt. Also, anything you learned through...
What I will say is the judge seems to deny everything. You notice that? Everything, right? It's like every motion that they're putting forward, the judge is saying denied, okay, denied. But they putting it on record, so, so everything's on record. But you already know before they even put it on record, he's going to deny it.
Representation is confidential and you cannot be compelled to reveal it except for a court order. I'm not sure that the judge simply unsealed telling the source was proper court order. This was truly troubling and I'm so glad that cameras caught the proceedings. In the most sympathetic possible reading, there was a threat to the witness and he wanted reassurance that he'd be safe. But defense counsel still gets to hear that. If a threat keeps a witness from testifying, state can claim defendant forfeited right to cross. This totally secret ex parte meeting is not like anything I've heard of before, and I couldn't find a case on point with it. Really strange. Ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues. The judge makes provision promptly to notify all the parties of the substance of the ex parte communication and gives the parties an opportunity to respond, which he did not do. And that's from Rule 2.9, assuring fair hearings and averting ex parte communications. Lester Tate's another lawyer. He tweeted, "I've repped lots of judges and folks accused of contempt. We'll be shocked if this is not reversed. It's indirect criminal contempt in which the judge is involved. Should have been referred to another judge for handling." Can't wait to read Judge Glanville's order. Does he now think this ex parte issue goes away because the lawyers are going to ask the witness about the conversation? That's where it's going to get interesting. On cross-examination, the lawyer's going to ask Kenneth Copeland about what was said and what he said, what the judge said. I honestly don't see how this trial continues. We have to start all this over and then it's just delayed more. The trial might be over, boys. Absolutely insane. Hit subscribe, comment down below, join the channel.
Crazy, right? Basically, I can give it to you in layman's terms. Stay away from people, man. A lot of times you start hanging out with people and you get into their drama, and you end up having.
Okay, so we gotta talk about this, Charlie.
You know what I mean, like that.
Love what you find. Only at Total Wine and More.
Okay, so we gotta talk about this trial in Georgia where it seems like everyone is going to jail. Like, here's a juror who had to go to jail.
The judge slaps a potential juror with jail time. Her offense, shooting video of courtroom proceeding.
One of the court officers also went to jail.
Developments tonight involving yet another twist in this ongoing YSL RICO case. We're talking about a Fulton County Sheriff's deputy arrested earlier today and accused of trying to smuggle contraband to a defendant in the case. This deputy, Akiva Stanley, in this mugshot here.
And even the lawyers have been having problems. Here's one defense attorney who the judge said, because you're late, you got to either write me a paper or you got to go to jail.
Next matter, Mr. Johnson. How are we doing on that paper? I mean, the importance of professionalism. Yours is due by the 28th of April. I'm just clocking. So we on track?
You ain't gonna write it. You'll have a secretary write it.
Well, you better have said she's not writing it for you either.
You know she is.
Okay, well, just want to let you know that, okay? All right, so we're good?
You know she gonna write it.
I'm sorry? Because that wasn't offered to you. You already asked me, could I pay the $1,000? I told you no. Well, I know you would, but that's not what's on the table. 28, yes, at noon. Or you do 20 days. Okay, 17-page paper on the importance of professionalism in the legal field and treating one's opponents with civility. Paper is to be published quality in APA format and at least 10 primary and 10 secondary sources. Means that we should be able to send it to the to either the Georgia any one of our law review or any other place that accepts publications, and it should be acceptable.
Just so you understand, it was either 20 days in jail or write a 17-page paper. Now, even though that guy was threatened to be put in jail, we got two other lawyers who actually were put in jail.
It is now at noon. A defense attorney with the YSL RICO case has been arrested. Officials say attorney Astasios Menetas was arrested this morning in the Fulton County courtroom. This is video when we spoke to him earlier this month. We're told he's facing several charges, including simple battery on a law enforcement officer, obstruction, and disruption of court proceedings.
Nicole Fegan, she was arrested today in Gwinnett County stemming from a September 2022 deadly shooting in downtown Atlanta, not far from Centennial Olympic Park. Fegan is not accused of shooting anyone, but Atlanta police say investigators learned she contacted a suspect in the shooting and told him there was a warrant for his arrest. Investigators say she learned about that during a court hearing related to the shooting. Police say she told the suspect, who they aren't identifying, to dispose of his phone as police were going to arrest him. Detectives say Fegan was not representing the suspect that she called. She faces 2 charges: participation in criminal street gang activity and solicitation to tamper with evidence. Fegan represents YSL defendant Tinquarius Mender.
And now we have another defense attorney who has been arrested and sent to jail for 20 days.
Basically, guys, that was an hour and 30 minutes. I just wanted to give y'all some of the YSL cases. In conclusion, like a Jerry Springer, you know, eventually what you do days and days and months and years eventually will come back to you eventually. So just watch what you do out here. Even myself, watch what you do. Try to stay positive in everything you do. And just always try to encourage everywhere you go. Try to, you know what I mean? You see negativity, it's always going to be out there. But try to stay away from it, guys. You know what I mean? Because if not, you're going to have to deal with these people. You want to deal with judges and lawyers and courts and people dissecting your life, or you want to live a good life? I'm about to go eat some steak and lobster right now, and pasta. You know what I'm saying? Have a great day.